Good day. My name is Meggan Watson and I am a legal advisor for Labour, Consumer Protection and POPI here at SEESA's Port Elizabeth branch.
Good day. My name is Sandrisha Govender and I'm also a legal advisor for Labour, Consumer Protection and POPI at SEESA's Port Elizabeth branch.
Today, we will be discussing one of the chief objectives of the Consumer Protection Act, that is, to promote a fair, accessible and sustainable marketplace for consumers. The Act establishes norms and standards related to consumers' protection, and the Act prohibits certain unfair marketing and business practices. The Act promotes a legislative framework for consumers in respect of consumer transactions and agreements. The Act places emphasis on putting consumers in a more favorable position than they previously were prior to the commencement of the Act. And furthermore, the Act protects these consumers against any unfair, unreasonable, or unjust contractual terms. Now, Sandrisha, can you advise us which section of the Act deals with unjust, unreasonable, or unfair contractual terms?
Yes, Meggan. Section 48(1) of the Act provides that a supplier may not offer to supply or enter into an agreement to supply goods or services on terms that are unfair, unreasonable, or unjust, or at a price which is unfair, unreasonable, or unjust, or market any goods or services, or conclude any transaction or agreement in a manner that is unfair, unreasonable, or unjust, or require the consumer to waive any right, assume any obligation, or waive any liability for the supplier on terms that are unfair, unreasonable, or unjust. Now, Meggan, could you please provide us with more guidance or highlight the circumstances under which certain terms may be seen as unfair, unreasonable, or unjust?
Thank you, Sandrisha. Section 48(2) of the Act advises us that any term in an agreement would be found to be unfair or unreasonable if that term is excessively one-sided, so in favor of any party other than the consumer to which the goods or services are supplied, or where the terms of that agreement are seen to be so adverse as to be inequitable. And of course, when entering into the agreement, at the time of entering into the agreement, the consumer relied upon a misleading or deceptive representation or statement made by the supplier to the detriment of the consumer. Now, Sandrisha, would you be able to provide us with further examples of presumably unfair contractual terms?
Yes, Meggan. Regulation 44(3) to the Act provides us with examples of terms that are presumed to be unfair. An example would be a term allowing the supplier to claim any legal costs on a higher scale than normal, without also giving the consumer the right to claim legal costs on the same scale. Another example would be a term allowing the supplier, but not the consumer, to cancel the agreement under certain circumstances. Now, Meggan, I understand that the supplier has a responsibility to ensure that the consumer understands the implications of the agreements that they are entering into. Could you please elaborate on this?
Of course, Sandrisha. Section 49 of the Act advises us, in particular when looking at indemnity and liability clauses, that there are three requirements that need to be adhered to, and that is that the terms of the agreement needs to be in a plain and understandable language for the consumers. And then, of course, the nature or consequences of those terms need to be brought to the attention of the consumer. And thirdly, the consumer must be given an opportunity to revise and fully comprehend the terms of the agreement. So this opportunity can even be in the form of a cooling off period at the conclusion of the agreement. Now, Sandrisha, in any disputes over allegedly unfair contractual terms or clauses, what recourse would you say the consumer has against the supplier in such instances?
A consumer who is faced with an unfair term may refer the matter to the relevant ombudsman, the applicable consumer court, if any, another alternative dispute resolution agent, or the National Consumer Commission. However, the court may only approach the civil court if all of these remedies have been exhausted. In this case, the court may order the supplier to restore any money or property to the consumer, compensate the consumer for any losses or expenses incurred relating to the agreement or the costs of court, or require the supplier to cease any practice that may cause further harm to the consumer. In extreme cases, the court may even declare an agreement to be void in its entirety.
Thank you, Sandrisha.
Thank you, Meggan.